Hi, my name is Carl Pearson, and this is video number 128 entitled Any Loan Mod Ends a Foreclosure Action. I'm a New York attorney, and I spend most of my time defending against home foreclosures throughout the 50 states. I'm also a graduate of Harvard Law School and have spent most of my effort as an attorney since 2008 defending against residential foreclosures. That's 1 or 4 units. At the outset in 2008, prior to the statute known as HAMP and the takeover defenses of issues such as robo-signing and standing, I prepared my second video of the 150 or so that I've made and published, urging foreclosure-threatened homeowners in judicial foreclosure states not to pay their monthly mortgage so that they could have some money left to hire the legal skills they needed to oppose the threatened foreclosure action and have a better chance of saving their mortgage property, that is, their home. Now, 7 years later, another basic judicial foreclosure matter needs to be discussed, which may seem at the outset just as off the wall as my 2008 advice to homeowners threatened with a judicial foreclosure to stop paying their mortgage before they ran out of money to hire an attorney. This basic matter is the loan modification agreement that may be offered to you by the owner or holder of the mortgage note or the loan servicer. A proposed loan mod agreement in some cases is quite satisfactory to the homeowner, especially when it contains a low interest rate such as 2 or 3% and a principal reduction, sometimes amounting to several $100,000 or more. So we're not talking about that kind of loan mod if you can get it. The real problem is why I'm doing this video, which is what does a homeowner mortgagor do when the offered loan mod agreement is not affordable? Let's assume that the required monthly payment under the proposed loan mod agreement is $1,700 and that the homeowner mortgagor can only afford $1,200 per month. What should the homeowner do? Well, here's what I've been telling homeowners. HAMP loan mods are coming to an end for some of the major banks, and many lenders and services are not obligated to give loan mod agreements under HAMP anyway, especially vulture funds which purchase groups of defaulted mortgage notes. Also, consider that Fannie Mae and Freddie Mac are not required by HAMP, even if HAMP applies, to offer principal reductions, which makes loan mod offers even less attractive when the note is owned by Fannie Mae or Freddie Mac. Let me explain how this situation often arises. The holder of a defaulted note in one of the 22 judicial foreclosure states commenced a foreclosure action after months of effort by the homeowner to obtain a loan modification agreement, which application or applications were denied by the lender or its servicer. So let's assume that. As a result, the foreclosure action was commenced to obtain an order permitting the lender or its servicer to sell the mortgage property. But in most, if not all, of the 22 judicial foreclosure states, the homeowner is given an opportunity at the outset of a foreclosure action to try to enter into some type of loss mitigation transaction with the lender or servicer, which means if the homeowner is going to remain living in the mortgage property, that the homeowner has to obtain a loan modification agreement as a result of this loss mitigation period, called mediation in most states, but called conferencing in New York State. All of the other loss mitigation options involve loss of the home, unless the owner pays all or a substantially high percentage of the total amount owed, which now usually amounts to far more than the principal amount of the note because of the higher default rate of interest, unpaid monthly payments, legal fees that have now accrued to the bank, and other costs. During this mediation or conferencing period, which can last several months up to several years, which is rare, I should add, the homeowner is trying to obtain an affordable loan mod agreement, and the lender or servicer all too often either says the homeowner does not qualify at all, in which case the matter goes into litigation. The lender or servicer makes a motion for summary judgment for foreclosure and sale unless the attorney for the homeowner puts up a good fight. The court all too often will grant judgment against the homeowner and permit the mortgage property to be sold by the lender or servicer, sold at auction, and the new owner will then start eviction proceedings to remove the mortgager and his or her family from the premises. On the other hand, the lender or servicer may offer an obviously unaffordable loan mod agreement. What do you believe the homeowner should do? Because the offered monthly payments are not affordable, conventional wisdom is to counsel the homeowner to reject the offered loan mod agreement. If an offered loan mod agreement of this type is rejected, the lender or servicer may not be required to revive the offer, or perhaps through litigation the offer could be revived, maybe improved, or possibly even made less affordable, if anything at all. There's all sorts of possibilities here, but remember now that the lender or servicer has no duty to make another offer. They often say, we made it and that's it, and walk away. So you have that one chance, and you have to remember you can't, there's no right to revive that, generally speaking. Now there are some exceptions, but I can't really go into everything here. And the exception would be based on bad faith, an argument which you still have if you need it. So the homeowner is faced with a business judgment as to whether to reject the offer, even though this might lead quickly to a foreclosure, auction and sale of the property, and eviction from the premises, or accept the non-affordable loan modification agreement. Here's the thing to consider about not accepting the non-affordable loan mod agreement. One, if you don't accept it, there may not be any other offers. Two, a judgment of foreclosure and sale may be granted shortly thereafter. Three, your property will be sold at auction after a short period ranging between 10 and 90 days, depending on the jurisdiction. Four, within 2 to 3 months after the sale, you can be evicted from the premises. On the other hand, if you accept an offered non-affordable loan mod agreement, the foreclosure action will be dismissed, that is discontinued, and there will be a waiver of your current defenses, including your challenge to note ownership, I should add. All you need to do is pay the 1 to 3 trial monthly payments, and recently there have been many loan mods without any trial payments. And if there are these trial monthly payments, you make them to get the permanent loan mod agreement, or it's given to you directly. Then you make several monthly unaffordable payments under this permanent loan mod agreement, and then stop paying them the mortgage. Stop. The lawsuit will have been discontinued by that time, and the lender or servicer would have to start all over again with a new foreclosure action, which you could then stretch into a period of 2 to 4 years or more of non-payment before having another sale and eviction crisis, but with another possibility, probably not as great, of obtaining another loan modification agreement. Your defenses the second time around, however, will be reduced, which you have to consider. That is, you no longer have the argument that the note is not valid because you have signed, in effect, with this in settlement, you waived that defense, and you can't argue that any longer. So even if the bank doesn't own the note, in fact, you will have consented to its ownership and be bound by that. And also, you probably will not be able to sell the property and transfer the benefit of this permanent loan mod agreement for a few years, or quite a few years. You need to consider this aspect as well. So when faced with this problem, ask yourself, is it better for you to be evicted in 3 to 6 months by rejecting an unaffordable loan modification agreement, or accepting the unaffordable loan mod agreement and having a possible or probable eviction 2 or 4 years after this time? and during that 2 to 4 year period, you're saving, say, $1,200 or $1,700 a month for almost, say, up to 50 months. That's a lot of money that you're saving as a result of this, which gives you enough money theoretically to go out and buy something affordable for yourself and be able to have some equity in your home ownership. You might also be thinking of some bankruptcy to get rid of some debt along the way. So I view this as a business decision that the client has to make. In the long run, many of the issues that foreclosure defense attorneys raise in the defense of foreclosure actions are often disregarded by the judges who decide summary judgment motions for foreclosure and sale. The judges often bend over backwards, I will admit, when there is an opportunity for a homeowner to obtain a loan mod agreement, and especially when it is affordable. But when any type of loan mod agreement is not to be offered, or when one is rejected, the case goes back into litigation, and judges and appellate courts at that point seem to have far less concern for the homeowner and are quite willing to render a judgment of foreclosure and sale. The homeowner has a much better chance of keeping his or her property through mediation or conferencing in New York and obtaining a loan mod agreement than he or she does through winning a foreclosure action from a statistical standpoint. Also, when a judge orders foreclosure and sale, the appeal of such an order also has perhaps only one chance out of 10 or 20 in prevailing, which are not good odds when the 80 or 90% means you lose your home. Also, the filing of a notice of appeal generally does not stay the sale because the homeowner is not able to post a bond amounting to 110% of the total amount allegedly owed on the mortgage note. I want mortgagors in the judicial foreclosure states to think about what I've said as one more factor to take into consideration. Foreclosures are complicated, and trying to analyze what is best is complicated, especially in trying to evaluate the strength of legal issues that are involved. Some legal issues are far better than others, and the homeowner needs to obtain some insight on the strength of the legal issues. But be aware that the judge may still grant judgment of foreclosure and sale in spite of your attorney's evaluation of the strength of the issues. Another warning is that the homeowner too often has an outlandish and fully impractical idea of what defenses there are, and doesn't understand, and too often loses the property because they believe in what they have read, and they don't understand the complexity of foreclosure litigation and the likelihood that the court will just disregard almost all, if not all, or many of the issues that the homeowner thinks are going to protect him or her from losing the property. It just doesn't work that way, and you have to understand that at the outset. So if not moving out for the next 2 to 4 years is an important consideration, the homeowner should give serious consideration to accepting what appears to be a non-affordable loan mod agreement. It only appears to be non-affordable because the homeowner may have to make plans of not making payment within 2 months or so after the permanent loan mod begins. So it really isn't non-affordable. You're not going to pay it at all for most of that period of time. So if you have any questions, please give me a call. My telephone number is 212-307-4444. I can prepare answers and motions for review and use by a homeowner's local attorney in any of the 22 judicial foreclosure states, and provide assistance to the local attorney when he or she requests assistance. This could be an effective foreclosure team defense in any of the 22 judicial foreclosure states. My telephone number again, 212-307-4444. I look forward to hearing from you.